Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And we are here today to read Judge Ann Dunley's response to R. Kelly's defense team's motion to dismiss the RICO charges and I think it was the charges against Azriel and Faith Rogers. And so I believe he filed that motion back in February, maybe, and she's just now getting around to it. And for those of you who are new to me reading these motions and court documents in this case, they give a lot of, they give the codes and the statutes and court cases that they are citing. And just for the sake of time, I'm going to skip over those. But if you have a question about some of the codes or whatever, just leave them in the comments and I will answer your questions in the comments. And so it says the defendant is waiting trial on charges of racketeering in violation of United States Code 1962, 3 counts of Mann Act transportation, 3 acts of Mann Act coercion and enticement, 1 count of Mann Act coercion, and 1 count of Mann Act transportation. And those codes are all found under 18 USC, and then you just have to go through the various ones. There's like, I think, like this starts at 1963, and then it goes through to 24, 23, and it's just a whole bunch of statutes. So background, the third superseding indictment returned on March 12, 2020, charges the defendant with racketeering and violations of the Mann Act. The racketeering charge alleges an enterprise that includes the defendant and his managers, bodyguards, drivers, personal assistants, runners, and members of his entourage, all of whom have not been charged in this case. We know that Robert Kelly is the only one in this Eastern District of New York case that has been charged. So why they keep throwing all these other people in here is beyond me. Maybe it's because so many people were saying, how can you have a RICO Act when you only have one defendant? So they're trying to bolster their claim and pretend like, oh, it was this huge organization. So according to the indictment, the enterprise, which engaged in and affected interstate commerce, quote, constituted an ongoing organization whose members functioned as a continuing unit for a common purpose of achieving the objectives of the enterprise. The purposes of the enterprise were to promote the defendant's music and brand, so they've thrown that in for good measure, to recruit women and girls to engage in illegal activity with the defendant, and to produce video, including other videos. The defendant, through the means, and then I'm skipping over some stuff because you know YouTube run their bots and they look for certain words and they look for certain things. I am so hot about to pass out, y'all. I got this air conditioner on full blast, but it is very, very humid here today. And so you guys know I leave out certain words so that the bots don't pick up on it, right, and try to flag the video. And so it says the defendant, through the means and methods of the enterprise, is alleged to have committed 14 racketeering acts against 6 victims between January of 1994 and 2017. 2 of the racketeering acts, 12 and 14, and 4 of the Mann Act counts, 6 through 9, involve allegations that the defendant had intercourse with Jane Doe number 6, who we know is Faith Rogers, in violation of Section 120.20 of the New York Penal Code, reckless endangerment in the second degree, and Section 2307 of the New York Public Health Law, which prohibits someone who knows that he is infected with, quote, an infectious venereal disease, end quote, from having intercourse with another person In particular, the indictment alleges that the defendant engaged in unprotected sexual intercourse with Jane Doe number 6 without first informing Jane Doe number 6 that he had contracted herpes and obtaining her consent of sexual intercourse of these circumstances. Discussion. The defendant makes two challenges to the third superseding indictment. First, he argues that the racketeering count must be dismissed because the indictment does not allege a legally cognizable enterprise within the meanings, and then it gives a whole bunch of codes. Second, he moves to strike the charges that cite Section 2307 of the New York Health Law on the theory that the law is, quote, facially invalid, overbroad, and vague. And then it gives, where that can be found in his motion. And it says neither claim is persuasive. 1. Motion to dismiss count 1. Quote, the dismissal of an indictment is an extraordinary remedy reserved only for extremely limited circumstances implicating fundamental rights. United States versus De La Pava, and then it gives the case numbers, cited and internal quotation marks omitted. Rule 7 of the Federal Rules of Criminal Procedure requires that an indictment contain a, quote, plain, concise, and definite written statement of the essential facts constituting the offense charged, end quote. And then it gives some other codes. It says an indictment satisfies the rules of it, quote, first contains the elements of the offense charged and fairly informs the defendant of the charge against which he must defend, and second, enables him to plead an acquittal or conviction in bar of future prosecutions for the same offense. United States versus Stringer, and then also quoting Hamlin versus United States. And it says to withstand a motion to dismiss pursuant to Rule 12, an indictment, quote, need do little more than to track the language of the statute charged and state the crime and place, in parentheses, inappropriate terms of the alleged crime. United States versus Yanati and C. Hamlin again. It is generally sufficient that an indictment set forth the offense in the words of the statute itself, as long as, quote, the words of themselves fully, directly, and expressly, without any uncertainty or ambiguity, set forth all the elements necessary to constitute the offense intended to be punished. Indictments do not, quote, have to specify evidence or details or how the offense was committed. And a pretrial motion to dismiss an indictment must weigh the sufficiency of the evidence, end quote. United States versus Tucker, United States versus Alfonso. Finally, quote, when considering a motion to dismiss, the court must treat the indictment's allegations as true. And then they're quoting a article that was in a book or something. And then it says United States versus Valestigua, and then that person received a denial in their case. So basically what they're saying is when they write these indictments, as long as they are using the language that's set forth in the code, the penal codes, where they explain what each one of these charges is, that as long as they are using that information to describe the charge, then they don't have to prove in the indictment or, show evidence, supporting the indictment. They basically just have to write out the indictment, use the wording from the code in crafting their statements that they're making. And then if the grand jury go along with it, then the indictment passes. And so she's saying that because they met the criteria, that the indictment itself is valid. So it says the first count of the third superseding indictment charges the defendant with racketeering in violation of USC 1962. An indictment charging a violation of Section 1962 is sufficient if it alleges the following elements. 1, that the defendant was employed or associated with an enterprise. 2, that the defendant knowingly conducted or participated directly or indirectly in the conduct of the affairs of the enterprise through a pattern of racketeering activity. And 3, that the defendant knowingly committed or abided and abetted the commission of at least 2 acts of racketeering. And 4, that the activities of the enterprise affected interstate or foreign commerce. And then they cite United States versus Triumph Capital Group, United States versus Long. Those are the 2 cases that they're citing. The indictment alleges all 4 elements. Count 1 charges that from 1994 to present, the defendant was a member and leader of an enterprise, the activities and affairs of which affected interstate or foreign commerce. It alleges that the defendant knowingly participated in the conduct of the affairs of the enterprise through a pattern of racketeering activity, which was designed to achieve the common purpose of the enterprise to recruit women and girls for illegal activity and to produce videos. Further, it alleges that the defendant and other members of the enterprise committed 14 separate acts consistent with the enterprise's purpose and includes the approximate times and places of those acts. Accordingly, count 1 states the elements of the offense of racketeering, see Alfonso, and then says, we have no doubt that the count 1 of the indictment in the instant case meets these basic pleading requirements by accurately stating the elements of the offense charged and the approximate time and place of the robbery that defendants allegedly conspired to commit. So there was, in that what I just read in this case, the United States versus Alonzo, that is a quote from that legal proceeding that they are using to support what she's saying here. So United States versus Cooper, and they're pulling from that case because the government's allegations in the superseding indictment clearly strike and satisfy the elements, if proven, of the charged racketeering related counts, they are sufficient under Rule 7C. Nevertheless, the defendant maintains that the allegations in the indictment do, quote, not form a legally cognizable RICO enterprise under the law. First, citing Boyle versus United States, he argues that the government does not sufficiently identify the enterprise's purpose, the identities of the enterprise's members, the members' relationship with the enterprise, or the longevity of the enterprise. Second, citing a host of civil cases, he argues that the indictment's description of the enterprise is flawed as a matter of law because, quote, a party cannot be both the defendant person and the enterprise. And it says neither argument is persuasive. So that was what Steve Greenberg wrote in his motion, and she's now coming back saying she's not persuaded. So it says the essence of the defendant's arguments that the structural features discussed in Boyle are sub-elements of an enterprise that also must be alleged in the, what happened to my page here? Okay, let me start back over here. So she says the essence of the defendant's first argument is that the structural features discussed in Boyle are sub-elements of an enterprise that also must be alleged in an indictment. The government responds that the Boyle features are not essential elements of a racketeering offense that need to be pleaded to satisfy Rule 7. It maintains that the allegations of an association in fact enterprise by itself is sufficient, and that requiring it to plead an enterprise with the Boyle features is tantamount to challenging the evidentiary sufficiency of a properly pleaded indictment. Motion to dismiss an indictment for its failures to describe a valid enterprise, as the defendant argues, is premature at this stage. Premature at this stage. So I guess if he comes back with a stronger argument, she may be willing to listen to him. Then she goes on to say that in Boyle, the Supreme Court defined the element of an enterprise not in the context of evaluating the sufficiency of an indictment, but in ruling on the trial judge's final instructions to the jury. An indictment, by contrast, does not have to set forth evidence or details of how a crime was committed. Triumph Capital Group, and then they talk about that case, United States versus Carrier. Because an indictment is tested by its allegations, not by whether the government can prove its case, it is not subject to dismissal on the basis of factual questions, the resolution of which must wait a trial. Quoting Alfonso, and then it gives that case number. So basically what sounds like Judge Donnelly saying to us is that they can just make up some stuff, put it in an indictment, get the grand jury to say, oh yeah, they need to go on trial, and there's really nothing you can do. Like, they don't have to prove before the case that any of the stuff that they are alleging is true, which takes us back to they're just piling on these charges, hoping that he'll plead guilty to something because he doesn't want to risk going to trial. But then the more I read these responses from the judge, the more it appears that they really, really, really do not have a case against R. Kelly. So she goes on and says, whether the government can prove that the enterprise in this case has the structural hallmarks required by Boyle is a question of fact to be resolved by a jury at trial. In claiming that the indictment is insufficiently detailed in describing the enterprise, the defendant confuses the standards of pleading with the standards of proof at trial. However, the arguments in support of their claim reveal, and then she's reading here, this is taken from another case that he cited. And she writes, however, the arguments in support of their claim reveal the true nature of defendants' objections are not the sufficiency of the allegations, but rather the sufficiencies of the factual and evidentiary support that the government will likely use to prove the existence of the enterprise at trial, United States versus Ramir. And then from that case, she quotes Ramir posits that an indictment must spell out why a RICO conspiracy's predicate acts are both horizontally and vertically related. These arguments confuse the standards of pleading with standards of proof. Citation and internal quotation marks omitted. United States versus Messina. Rejecting pretrial challenge to relatedness as confusing the standards of pleading with the standard of proof. And then she goes through and she's mentioning these court cases where, that same statement appeared. And then she says, continuity is not an element of a RICO offense that must be alleged with particularity to survive a motion to dismiss. The defendant's arguments conflate that the government must prove at trial with what it must allege in the indictment. So then she goes on to say the government is entitled to marshal and present its evidence at trial, and the defendant is entitled to challenge sufficiency of that evidence pursuant to Rule 29 of the Federal Rules of Criminal Procedure. See Ramir 384, and then she gives all this codes. The sufficiency of the evidence is not appropriately addressed on a pretrial motion to dismiss the indictment, but rather on a post-trial motion for a judgment of acquittal pursuant to Rule 29. Citations and internal quotation marks omitted. United States versus Gambino. It is axiomatic that in a criminal case, a defendant may not challenge a facially valid indictment prior to trial for insufficient evidence. Instead, a defendant must await a Rule 29 proceeding or the jury's verdict before he may argue evidentiary insufficiency. Accordingly, the motion to dismiss count 1 on this ground is denied. So do y'all think that Steve Greenberg either don't know the law or he's just filing these motions to get her response, to get a feel of what they really have going on, to see if she's going to slip and put something in this motion that he can, in her response, that he can use when he's actually preparing for trial? Because the way she's responding to him is like she's talking down to him, like he doesn't know the law, he doesn't know what's going on. So here, let me educate you on how the law should work. And so I mentioned to you guys before that a lot of motions have to be filed. Even if you think the motion is going to be denied by the judge, you still have to file those motions. So in the event your client is found guilty, then you have, you have standards there in which to file an appeal. And so a lot of times when they're filing these motions, they already know that they're going to be denied, but they're just building their paper trail just in case they have to file an appeal. Let's see. The defendant also argues that the description of the enterprise in the indictment is flawed because it does not distinguish between the defendant person and the enterprise. To support his claim, the defendant cites only civil RICO cases, but unlike criminal RICO charges, civil RICO claims are governed by the heightened pleading standards in Rule 9 of the Federal Rules of Civil Procedure and Bell Atlantic Corp versus Trumbull. Criminal RICO charges, of course, are governed by Rule 7 of the Federal Rules of Criminal Procedure and are contained in an indictment returned by a grand jury. See United States versus Mavarales. A criminal indictment containing RICO charge is not subject to the same type of analysis to which civil RICO complaint would be subject on a motion to dismiss pursuant to Rule 12b-6, United States versus Marchese. Case numbers. The cases cited by the RICO defendants in support of their motion are in opposite. I think they spelled the word here wrong. Involving, as they do, motions to dismiss civil RICO complaints and not criminal indictments. See also United States versus Vaughn, declining to apply equitable Trumbull pleading standard to a criminal indictment. In other words, the enterprise person distinction requirement from civil RICO cases is not relevant to the legal sufficiency of properly pleaded criminal indictment. United States versus Gatto. Defendants' reliance on 2 civil RICO cases is confounding in moving to dismiss a properly pleaded indictment. So what they are saying there is that Steve Greenberg is using the wrong case law in his motion to dismiss, that he is pulling information from civil cases, not criminal cases. So it goes on to say the indictment in the case contains, quote, a plain, concise, and definite written statement of the essential facts constituting the offense charged, federal R crime P7C1, and makes out the offense of racketeering under Section 1962. Accordingly, the motion to dismiss count 1 on this ground is also denied. 2, motion to strike. The indictment alleges that the defendant transported one of the victims in interstate commerce, intending that she, quote, engage in activity for which a person could be charged with a criminal offense. The indictment identifies 2 offenses with which the defendant could be charged. Section 2307 of the New York Public Health Law, which makes it a misdemeanor for, quote, any person who knowingly himself or herself to be infected with an infectious venereal disease has intercourse with another, and section 120.20 of the New York Penal Law, reckless endangerment in the second degree, which is, quote, recklessly engaging in conduct which creates a substantial risk of serious physical injury to another person, end quote, a Class A misdemeanor. The defendant argues that the racketeering acts and the Mann Act counts that incorporate the violation of Section 2307 must be dismissed because Section 2307 is facially unconstitutional and facially invalid, overbroad, and vague. According to the defendant, the statute is overbroad because it bans people from infectious venereal diseases from having consensual sex, and is vague because it, quote, fails to define what is meant by sexual intercourse and what is meant by sexually transmitted disease. Even if the defendant were to succeed on his challenge to Section 2307, his motion to dismiss would fail because the indictment also alleges that he could be charged with violating the reckless endangerment statute, the constitutionality of which he does not challenge. In any event, his challenge in Section 2307 is meritless in the context of this case. And then it says A, facial versus as applied challenges. Quote, a facial challenge is an, she a teacher here, y'all, and she teaching Greenberg what the laws say. So I'm just like really finding her to be a little bit condescending here. So it says a facial challenge is an attack on the statute itself as opposed to a particular application. City of Los Angeles versus Patel. Such challenges are, quote, generally disfavored, end quote, because they assert the legal rights and interests of third parties. Dickerson versus Napolitano, listing the four rationales for limiting third party or just terti standing. See also Farrell versus Burke. It says, quote, federal courts as a general rule allow litigants to assert only their own legal rights and interests and not the legal rights and interests of third parties. And if you guys remember when he, in his motion where he was writing all this stuff, he was talking basically, and I pointed this out in the video that I did on it, where he kept bringing up these cases of gay people and basically saying that it was like gay people that had been arrested for having gay sex, anal sex, and how at one point that was unconstitutional, but then when they passed the bill that Obama passed giving gay people the right to marry, that they should have done away with any laws against sodomy and all of that. And so I thought that was kind of extreme at the time when he filed the motion. And so basically, I guess Judge Donnelly is agreeing that it was extreme. So she says, nevertheless, courts permit facial challenges in First Amendment cases in which the plaintiffs allowed to challenge a law that may be legitimately applied to his or her own expressive conduct if the law has the potential to infringe unconstitutionally on the expressive conduct of others. And that was Dickerson. And then she goes, citing Forsyth County, Georgia versus Nationalist Movement. Then she has, quote, it is well established that the area of freedom of expression and overbroad regulation may be subject to facial review and invalidation, even though its application in the case under consideration may be constitutionally objectable, end quote. Facial challenges to laws implicating First Amendment rights, quote, may go forward only if the challenge regulation reaches a substantial amount of constitutionally protected conduct. Farrell, she quotes somebody Farrell and then quoting Callender and Lawson. And then she goes on to say facial challenges outside the First Amendment context are different. First, the challenge law must infringe on a constitutionally protected right. The court has allowed, and then she's quoting from the Patel case, the court has allowed facial challenges to proceed under a diverse array of constitutional provisions, citations omitted. Then in the Dickerson case, Morales does suggest that facial challenges are permissible outside of the First Amendment context, but the case only permitted such a challenge in the presence of a constitutionally protected right. And then citing City of Chicago versus Morales, Stevens J. plurality opinion, and then a case involving someone named Farrell. Quote, when fundamental rights are implicated, the rules against just tertii, which I'm thinking must be a Latin judicial word, okay, standings are different. Second, the complainant must demonstrate that, quote, no set of circumstances exists under which the law would be valid. And then she's like United States versus Solero, Hoffman Estates versus Flipside. To succeed, however, the complainant must demonstrate that the law is impermissibly vague in all of its applications. Then she says, this has been described as, quote, the most difficult challenge to mount successfully, end quote, because the fact that the law, quote, might operate unconstitutionally under some conceivable set of circumstances is insufficient to render it wholly invalid. And that came from the Salerno case. She says, as the Second Circuit has recognized, the Salerno standard, quote, effectively eliminates facial challenges outside the First Amendment context that could not also be brought as an as-applied challenge, since any law that is unconstitutional in every set of circumstances is also necessarily unconstitutional when applied to any plaintiff. And that's from the Dickerson case. And so she goes on and she's quoting from these different cases. In the United States versus Rybakik, she quotes, collecting cases that have, quote, held that when the interpretation of a statute does not implicate First Amendment rights, it is assessed for vagueness only as applied, i.e., in light of the specific facts of the case at hand and not with regard to the statute's facial validity. The defendant is claiming a violation of his right to substantive due process, as the defendant explains in his opening brief. Then I think she pulled this from Greenberg's motion that he filed. It says, as written, Section 2307 is an improper invasion of the right to privacy because it makes it illegal to have private consensual sexual intercourse. Substantive due process prohibits the government from limiting the right to engage in private consensual sexual intercourse without fear of criminal liability. And then, like I say, he went on, and all the cases that he quoted were all cases of gay couples who had been arrested for sodomy. And then, is it marriage equality bill that Obama passed? But anyway, with the passing of that bill that basically legalized sodomy, because if two men get married, that's the only way they can have sexual intercourse. And so, as I stated previously, I thought that was a bad argument to begin with, but he went with it. So the judge goes on to say, accordingly, the defendant cannot succeed on a facial challenge to Section 2307 unless he can establish that there is no set of circumstances under which it would be valid. There are factual circumstances, including the conduct ascribed to the defendant, in which the statute is neither unconstitutionally vague nor infringe on substantive due process rights. Indeed, the defendant's claim that the law sweeps too broadly and captures some constitutionally protected conduct is fatal to his argument that the statute is facially unconstitutional. Under Salerno, a defendant lodging a facial challenge to a law that does not implicate the First Amendment must establish, quote, that no set of circumstances exists under which the law would be valid. That section 2307, quote, might operate unconstitutionally under some conceivable set of circumstances is insufficient to render it wholly invalid. And then B, as applied substantive due process challenge. Under the Due Process Clause of the Fifth Amendment, no person shall be deprived of life, liberty, or property without due process of law. U.S. Constitution Amendment 5. The Supreme Court has interpreted the Due Process Clause to include a, quote, substantive component guarding the individual against, quote, the exercise of power without any reasonable justification in the service of a legitimate governmental objective, end quote. Lombardi versus Whitman, and quoting County of Sacramento versus Lewis, in assessing whether a government law impinges on a substantive due process right, quote, the first step is to determine whether the asserted right is fundamental. Liebert versus Harrington, quote, rights are fundamental when they are implicit in the concept of ordered liberty or deeply rooted in the nation's history and tradition. Quoting Immediato versus Ryeneck School District, citations are internal. Quote, where the right infringed is fundamental, strict scrutiny is applied to the challenged governmental regulation. Liebart, Reno versus Flores, quote, where the claimed right is not fundamental, the government regulation need only be reasonable, related to a legitimate state objective. The defendant argues that he is asserting a fundamental liberty interest established by Griswold versus Connecticut, Lawrence versus Texas, and Obergefell versus Hodges. According to the defendant, these cases, quote, stand for the proposition that private sexual decisions made by consenting adults invariably involve a fundamental liberty interest protected by the Due Process Clause, one that absolutely shields private sexual conduct from the reach of government intervention. And then, so she's quoting from the case that he cited, private sexual contact between consenting adults involves a fundamental liberty interest that triggers a non-deferential review whenever the government seeks to prescribe such conduct. The court has recognized intimacy as a fundamental right. So she goes on to say the defendant's reliance on the lofty principles enunciated in Griswold and its progeny is misplaced. The charges against him are not, as he claims, premised on his, quote, private sexual decisions, end quote, or, quote, private sexual conduct, end quote. Rather, the allegation is that the defendant knew that he had herpes and engaged in sexual activity without telling the victim that he was infected. And the liberty interest enshrined in Lawrence was not, as the defendant claims, the right to make, quote, private sexual decisions, quote, end quote, but the liberty of persons, end quote, to formal personal relationships that find expression in intimate conduct. United States versus Stagliano. Then it quotes, whatever is evident from the Supreme Court's decision in Lawrence is its intent to prevent the state from burdening certain intimate consensual relationships by criminalizing the private sexual acts that are instrumental to those relationships. Sig Miller versus Leverkin, quote, a broadly defined right to privacy right to private sexual activity will clearly not suffice. The court has never endorsed an all-encompassing right to sexual privacy under the rubric of substantive due process. Reliable Consultants, Inc. versus Earl. Lawrence, speaking of the case, did not categorize the right to sexual privacy as a fundamental right, and we do not purport to do so here. Muth versus Frank. Lawrence also did not announce, as Muth claims it did, a fundamental right protected by the Constitution for adults to engage in all manner of consensual sexual conduct, especially in this case, incest. Williams versus Attorney General of Alabama. Although many of the court's privacy decisions have implicated sexual matters, the court has never indicated that the mere fact that an activity is sexual and private entitles it to protection as a fundamental right. Internal citation omitted. Accordingly, the defendant has not asserted a fundamental liberty interest that warrants the highest and most stringent standard of judicial review. Section 2307 survives rational basis review as applied to the defendant's conduct. Public health is a legitimate state interest. See Gary D. P. Excavating Incorporated versus Town Board of Town Hancock. Legislation pertaining to public health and safety consistently has been recognized as an important local interest. And Section 2307 rationally serves that interest by penalizing those who, like the defendant, have unprotected sex knowing they are infected with venereal disease. See Grattan versus People. Article 23 of the Public Health Law was enacted for the protection of the public to promote the detection and eradication of sexually communicable diseases. The statute requires certain examinations, proceeds for violation and treatment, and includes criminal penalties, including Section 2307. In other words, Section 2307 is rational as applied to the defendant. Now, what I don't like about what she's writing here is that she is assuming once again that he did indeed have herpes, that he knew he had herpes, and that he knowingly transmitted herpes to Faith Rogers, little nasty behind. And so I think in her wording sometimes she comes across as she's like already finding him guilty of stuff, when I think that that's just reckless and inappropriate. Like, she should be using alleged that he did this, but she's stating for fact in her comments that, oh, he did this, he had this disease and he transmitted it to this person. So it goes on to say Section 2307 might very well be unconstitutional if it were enforced against someone who informed his sexual partner of his diagnosis before sexual contact and obtained consent. That prospect seems unlikely, as New York courts have construed Section 2307 to include a disclosure element. See Fan versus Sabin. Also imposes a duty to disclose. Maharam versus Maharam, a duty to speak in the circumstances. Given the relationship of trust between the parties, can also be predicated upon Section 2307 of the Public Health Law. So I'm assuming that Maharam and Maharam were husband and wife, or husband and husband, or wife, and one of them sued the other. So it says, in any event, the defendant is not charged with having consensual sex with an informed partner. As explained above, the defendant cannot allege an infringement of the rights of third parties. The courts of the United States are not often willing to hear claims based on third party or I need to look this word up, just terti standing, in which litigants argue the unconstitutionality of hypothetical enforcements of the law rather than the actual enforcement that triggered the litigation. This means, of course, that let me copy this word and I'm going to look it up when I get through here. This means, of course, that there will be some situations in which an unconstitutionally vague regulation is allowed to stand because the enforcement of the regulation caused no direct constitutional injury to the parties before the court. An unfortunate but necessary consequence of courts' reluctance to adjudicate board constitutional challenges. Farrell, okay, she's citing here. Thus, the defendant must show that the application of 2307 to his conduct, having unprotected sex, knowing he had herpes, and without informing his partner, violated his substantive due process. As explained above, he cannot do so. Okay, so C, as applied vagueness challenge. The Due Process Clause, the 14th Amendment, requires that every criminal statute, 1, gives the person of ordinary intelligence a reasonable opportunity to know what is prohibited, and 2, provide explicit standards for those who apply the statute. Dickerson, quoting Gradnett and versus City of Rockford, alterations and citation omitted, quote, a plaintiff making an as-applied challenge must show that the statute in question provided insufficient notice that his or her behavior at issue was prohibited. The standard, however, is an objective one, quote, whether the law presents an ordinary person with sufficient notice of or the opportunity to understand what conduct is prohibited or prescribed, not whether a particular plaintiff actually received a warning that alerted him or her to the danger of being held to account for the behavior in question. Quote, even if a person of ordinary intelligence has notice of what a statute prohibits, the statute nonetheless may be unconstitutionally vague if it authorizes or even encourages arbitrary and discriminatory enforcement. And quoting Hill versus Colorado, nevertheless, a law need not, quote, achieve meticulous specificity, which would come at the cost of flexibility and reasonable breadth, end quote. Moreover, and this is another quote, moreover, a statute that provides what may be unconstitutionally broad discretion, if subjected to a facial challenge, may still be upheld as constitutional on an as-applied challenge if the particular enforcement at issue is consistent with the core concerns underlying the statute, such that the enforcement did not represent an abuse of the discretion afforded under the statute. Okay, Section 23. I'm almost done. This is the last part, you guys. Section 2307 of the New York Public Health Law provides that, quote, any person who knowingly himself or herself to be infected with the infectious venereal disease has sexual intercourse with another shall be guilty of a misdemeanor, end quote. A person of ordinary intelligence would understand that he could be charged under Section 2307 for engaging in sexual intercourse, knowing himself to be infected with herpes. The defendant argues that the law is vague because it does not define sexual intercourse or what constitutes an STD. According to the defendant, it is not clear to an ordinary person that, quote, sexual intercourse, end quote, means sexual intercourse and not kissing or anal intercourse, or that venereal disease includes herpes. Quote, even if there is ambiguity as to the margins of what conduct is prohibited under the statute, Dickerson states that it is clear to an ordinary person that Section 2307 prohibits him from having sex knowing that he is infected with herpes. Finally, the conduct alleged in the indictment falls within the, quote, core concern, end quote, of the statute to protect the public from the spread of infectious diseases. Conclusion: the defendant's motion to dismiss and motion to strike are denied. So ordered. Ann Dunley. Brooklyn, New York, May 22nd, 2020. So, it really doesn't require repeating again. I thought the motion was dumb to start with. And so once I was right, it was dumb to start with. Now, my thing with the New York, the public health thing that they're going on. So R. Kelly doesn't live in New York, right? He's from Chicago. And regardless of where you're from, how many people, before they have sex with somebody, go and check the public health laws to know, first of all, and we're just saying, even if you know you have a sexually transmitted disease, how many people go and check the laws? Like if you go on vacation, okay, so say you live in Florida and there is no such law, which I don't know, I haven't looked. But just say you live in Florida and it's okay to have sex with somebody and know that you have a sexually transmitted disease. Because my understanding is like, I know if you know you have HIV, that's criminal, I think in most places. But talking about herpes where like 75% of people, I can't remember the number, I said it in the last video, what percentage of people between the ages of like 20 and 45 or 54 or something are infected with HIV, not HIV, but herpes. So say you know you have herpes, okay, and you live in Florida and people don't care if you got herpes in Florida. And I don't know this for sure, I haven't checked, I'm just speaking hypothetically. And then you go on vacation in New York and you meet some random chick at the club and y'all go back to the hotel. Are you going to go on the public health website to see if it's against the law to have sex with this person, knowing that you have herpes? Or even if you don't know that you have herpes, do you go every place that you travel to and look up the laws to see what is legal and what is not legal? I mean, like, to me, this whole, and maybe that's why it's a misdemeanor and not a felony, because they know it's so stupid. And then just reading the judge's response to the dismissal, it kind of like lets me know that if they can come correctly with this case, that they can easily get this Faith Rogers crap thrown out. And then another thing that I had meant to bring up, in the Azriel cases, in Jane Doe number 5 cases, where, do you guys notice that R. Kelly met Azriel in April? Her parents allowed her to travel with him over the summer, right? And do you remember when the sister was on Surviving R. Kelly? And I'm not going to go back and watch it to verify, but I swear that sister said that she traveled with Azriel over that summer when she first went to stay with R. Kelly, and then things got out of hand, and I guess there was a fight or something that broke out, and she was like she had had enough and she was coming back home. So I'm thinking this is why the charges in the New York indictment are only for September and October. They don't include, you know, all these months that she spent with him over the summer as having sex, or maybe they're figuring, okay, well, the sister was with her or whatever. But anyway, so her allegations are September through October. Those are the dates of her charges. And then it's like New York and California, and it's like they picked up states that they may have traveled to where it would have been illegal for him to have sex with a 17-year-old. And so it just seems to me that it's going to come down to he say, she say, because if she's saying, oh yeah, we had sex between September and October, and then he says, no, I didn't. I mean, you were traveling with me, but nothing happened. How do they prove that anything happened? And then also, does Azriel have herpes? I mean, why is it that Faith and then, you know, Geronda just tag along to whatever everybody else is saying? Why aren't all these other people claiming to have herpes? Why don't Haley have herpes? Why Sarah don't have herpes? Like, does Jocelyn have herpes? I mean, like, what is going on? Child, is just too much. And then I'm gonna go back, guys, and read this article because this person, she actually has a YouTube channel, but I follow her on Twitter. Her name is Cherise, and she reminds the article, and I'm going to do another video tonight where I'm going to cover that BuzzFeed article. And now that that precedence series has come out, that I'm also going to cover. So y'all can get a bunch of videos from me in the next couple of days. And then I still need to start my YouTube series that I was going to do on how YouTube channels work, all the inner workings and the games behind the scene that YouTube plays not to pay people their ad revenue and all of that. But anyway, I'm going to go ahead and end this. I'm going to come back and do another video on that BuzzFeed article. And then probably over the next couple of days, I'll do my review of Precedence, each part of Precedence. I'm going to go back and watch each episode. And then I'm also going to do a video on how poorly Shabazz rolled it out and why he has lost so much money, or lost the potential to make so much more money than he's actually going to make. So let me go ahead and wrap this up. Just want to come back, as I always do, and read the motions to you guys. And in this case, she has denied the motion to dismiss the RICO charges and the charges involving Jane Doe number 6, who we know is Faith Rogers. So guys, that's it for me. Rate the video, leave your comments below, share the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.